The Honorable Willow Supreme Court.
Good morning, please be seated.
Good morning, Your Honors. The matter before the court this morning is a case entitled Injury Petition of Chelsea Solar LLC, docket number 2019-226. Representing the appellant, Chelsea Solar LLC, is Thomas Melone. Seated at the counsel table with Attorney Malone is Kimberly Hayden. Representing the appellees, Apple Hill Homeowners Association, Mount Anthony Country Club, is Brooke Dingledine. Seated at the counsel table with Attorney Dingledine is Sarah Seaves from the Vermont Department of Public Service.
Okay, and I understand we have an agreement about how you're splitting up your time, right? You've all got an agreement to this?
Yes, Your Honor.
Okay, thank you, counsel. All right, counsel, please go ahead.
Good morning, Your Honor. Tom Melone for Chelsea Solar.
Good morning.
I wanted to start out by showing the court exactly what we're talking about in terms of the solar projects. Here on my right is one of the renderings that were done, which would show combined Chelsea Solar and Apple Hill Solar projects from the Vermont Welcome Center down in Bennington. These are in a printed case. As you can see, you can't see the project, or either project. On the left is the winter view. Off these conditions, you can barely see some of the solar panels from the Apple Hill project. You can't see the Chelsea project at all.
Those digital images or those renditions? I can see the aerial photographs in the corner. The pictures themselves, are those just an actual digital camera, or are those just renditions of what it's supposed to look like?
Oh, so these were prepared by our expert using a computer program to provide the as-built view of what they would look like.
These are part of the printed case, right?
Yes, Your Honor.
Yeah. And we have an agreement, I assume, to have you demonstrate them to us. Yeah, okay.
Yes, Your Honor, we do.
Yeah.
This is also from the printed case. It's the summer view from Route 7 North. As you can see, you can't see the project at all.
Help me understand how these pictures illuminate whether there's one project or two behind those trees.
How did we determine?
Well, you're showing us these images and I'm just trying to, is this just context you're giving us, or is your view that this helps us understand whether it's one project or two for the purposes of?
Oh, I think the main point of this is to give the context to what the projects look like and to show the court that based on what the project will look like, it seems to me anyway impossible to conclude that these have an adverse, undue effect on aesthetics. You really can't see the project.
So you're sort of skipping to the second issue.
I was going to get to the first issue after I just display these.
Got it. Thank you.
To give you context for the actual projects. And this is the house or the view from the house of the neighbor. In the summer and winter, and in both cases, they can't see it. So our first issue was on the single plan, whether the projects are one or two plans. In our view, this court decided the issue in 2014 that there are two separate plans. PUC, in their order, relied on three factors here to make their conclusion that these were one project. First, two, common ownership and proximity. This court rejected as factors in 2014, but yet the PUC relied on them again. And the proximity and the common ownership hasn't changed since 2014 for both these projects. The new part of the PUC's argument was that the project share infrastructure. This is also not true. They based their decision on the fact that GMP will build and GMP will own a line extension to bring electrical power to the site.
Well, you were offered a common connection point, were you not, for both projects, and you rejected that? Is that accurate?
No, we've always had a separate interconnection point for each project. So in the original plans in 2014, we expected that we'd be able to connect one project to the south, one project to the north. GMP did the system impact study and determined that based upon their review of their system, the best way to connect the projects would be to have both projects connect to the south, but still have separate points of interconnection.
That's what they said?
Yes, that's in the system impact study, and that's in the printed case. So originally we applied for connection to the north and one to the south. They came back and said this would be the best plan to do a line extension that comes from the south that can accommodate both projects.
And this is one transmission line?
It's one distribution line, that's correct.
Distribution line.
Right, one three-phase distribution line. So they have to upgrade part of their existing system to single phase, and then they add some three-phase power. And they have to bring electrical power from where it is now on Willow Road, which is at the last house, all the way up to the property. The GMP has an obligation to do that, whether it's a solar project or a house. They still have to bring power up to the lot.
There's some assertions here that there were misrepresentations back in, at the time of the original application, and that has some bearing here today, and I'd like your comment on that.
I do have another report on that, Your Honor. It is in the record, but it's not in the printed case, so I can show that to the court. I'll hold this one up. So, this is the solar property down here. In the 2014 case, we originally thought we would be able to interconnect here. When GMP did the system impact study, they said we should connect to the south. So in the plans that were submitted to the PUC and then up to this court, we drew in a right-of-way to this drive, which is north. This is an excerpt from the plans of the Apple Hill Solar, the Apple Hill subdivision. These are on file with the land records. ROW means right-of-way. Now, the developer who developed this, Paul Boney, testified in a deposition recently that his intention of this right-of-way was to allow this property to access Russet Drive
Can I,
if there were any development.
are we, and I realize this is true for the allegations in the brief as well, but are you now telling us things that are in some other record, not in the record of the case in front of us, the testimony?
Well, no, they're not in the printed case, but this is in.
No, the testimony that you were just describing to us. In a
Oh,
recent,
testimony.
You said in a recent deposition, which caught my ear as maybe being something outside of the record.
Right, the testimony is not in this record.
Okay.
But this is, and our assertion that the only beneficiary, when you look at this right away, is this property. And I mentioned the deposition testimony because the person that developed this confirmed that that was his intention, that this property would have the benefit of this right of way if they developed the property. So we don't think there was any misrepresentation at all to the court. It's based on facts. And the existing right of way that's drawn on the plans. So getting back to the single plan issue, we had a separate interconnection then in 2014. We have separate interconnections now. We don't share common equipment. which is another factor to find a single plan. Now, the PUC didn't make any findings on that, and all the evidence establishes that we have separate equipment.
Isn't it in your interest to have separate equipment so that you can get 2 sites instead of 1? It's an easy process to get separate equipment.
Yeah, it's an easy, I mean, you basically build the solar facilities as separate entities. You know, as if one were, so it's built as if, you know, the same as if one were on this site and one were 10 miles away. I mean, yeah, it is easy, but it's more expensive. I mean, it's more expensive to build them as separate projects. Now, the interconnection is not more expensive, but there's really no cost savings in total by building this as separate projects.
So as I understand the intervener's argument, the understanding that, yes, the GMP extension exists outside of the respective points of interconnection, but it's still currently non-existing infrastructure that will be built for and funded by the developers of this project. And as I understand the PUC, it said that's functionally what the statute is really getting at, that whether or not it's inside or outside of the point of interconnection, we've got a developer needing to fund extension of the underlying infrastructure. Why don't we owe deference to the PUC in that analysis?
Well, the statute specifically says in terms of infrastructure connections to the electric grid. So if we did it the way where we had a private line that connected to the electrical grid, a single private line, then I agree we'd be sharing a connection to the electrical grid. But GMP owns the electrical grid. I mean, the fact that we reimburse them for the cost of their electrical grid doesn't mean that we have any rights to it or own it, or that we're connecting somehow at the end of the extension. We're still connecting at the beginning of the extension where the electrical grid then is. And not every utility has a policy that requires the reimbursement of upgrades. It's really up to the utility. So some utilities put in the rate base, but utilities are allowed to charge customers for upgrades, and GMP does. But it's their system. The extension becomes part of the electrical grid. And I think as a legal conclusion, it's just wrong.
Could any member of the public decide to build on adjoining property and use that distribution line?
Yes, they can. In fact, the town of Bennington encourages solar projects for all homes up to 150 kilowatts, and all those would require 3-phase power. So all the homes now that run alongside this line could connect to that with basically no cost now. So, and that also goes to the point that if it were a private line, they couldn't connect to it. But it's not a private line, it's part of the new electrical grid. I'd like to reserve the rest of my time.
All right, thank you. Councilman.
Good morning, Your Honors.
Good morning.
My name is Brooke Dingledine, and I represent the Apple Hill Homeowners Association and the Mount Anthony Country Club, who intervened in this case. First, I just wanted to say on the single plan issue, I would like to just emphasize how important it is to follow the standard of review. This court gives great deference to the board's interpretation and judgment because they have expertise. They understand shared equipment.
Why isn't I understand that there's been a change since the programmatic use decision, but why isn't the remedy for that change to be essentially a 60B motion challenging that determination, which then is foundational to this next part of the process? I'm procedurally having a hard time getting my head around plugging that in now at the CPG stage.
Well, my understanding is the Public Utility Commission, it became aware when they were processing the Apple Hill Solar as well as the Chelsea Solar cases, And they even renamed this Chelsea 2 application, in parentheses, Willow Road. And it came to their attention that the reason why the Supreme Court said that they were separate plans, no shared infrastructure, no shared roads, was incorrect. And they opened up an investigation, they asked for comments, the interveners collected information and submitted it. So procedurally, it's before this court because it's a substantive decision by the Public Utility Commission that it is a single plan and violates that original contract from 2013.
And so maybe my question is, I can't ask them that, and I'm trying to figure out why they didn't reopen that other docket and pull the decision and amend it to say, oh, I mean, in other words, as the record stands now, we still have a final determination that these are two distinct projects for the purposes of the standard offer program. They're entitled to standard offer. That generates a bunch of presumptions in the certificate of public good. And now we're sort of back channel saying, well, even though that's a final unappealed order that hasn't been touched by a 60B motion, we're reversing it. I'm just trying to figure out how to untangle that.
It is a little complicated. And I think ultimately it comes down to a breach of contract of the representations that were material that were made at the time of obtaining the standard offer contract, and then again at this court. It was incumbent upon the appellants to come to the Public Utility Commission and this court to correct the factual misrepresentations, and instead they stand here before you today trying to argue res judicata that you don't get to go figure that out again, even though the facts have changed and they provided information that they knew to be false at the time. The Rusty Tribe doesn't exist, they have no rights whatsoever, and I'm not sure what this map exactly shows. But
The false information that you're saying, though, you spent a lot of time talking about that right away. I didn't see any findings in the PUC's decision that suggested that there's a finding of some misrepresentation on that. Are you asking us to, on appeal, go through the record and decide there was a misrepresentation, sort of make factual findings?
Well, I think it is. I don't know whether this court would choose to make any findings about the veracity of that information. But I think the reality of it is, what is the facts? What are the facts right now? Mr. Melone talked about how GMP would be building an extension. They already have. The applicant has already proceeded at their own risk. Hired GMP. GMP's already put in all the power lines and the power poles and the power lines.
Do you agree that other folks can access those?
Oh, absolutely. Sure. But switching to something that I submitted on Friday, on Thursday night I received the Public Utility Commission's decision on Apple Hill Solar, which is the twin site that this court remanded to, reversed and remanded to the Public Utility Commission because there is a clear written community standard. They relied on incompetent evidence that this court threw out. For example, the settlement agreement with the town of Bennington, where they caved and they said enough is enough. They got $200,000 to reimburse them for all their attorney's fees and all the various litigations, and they settled and said we're withdrawing from all the cases. Public Utility Commission in Apple Hill made the decision based on that, or the inference, that in fact the town of Bennington supported these projects, or that project, and that was incorrect, and this court has remedied that, remanded it back to the Public Utility Commission. This past week, a decision was issued that in fact said what Chelsea 1 did in docket number 8302 at the PUC, that was Chelsea 1, and it again said it is a clear written community standard now that we've thrown out the bad evidence that the Supreme Court would not allow us to rely upon, and the hearing officer has now produced a recommendation for the Public Utility Commission's decision in Apple Hill Solar that says it is a clear written community standard. They don't pass muster on the town plan being a clear written community standard for purposes of orderly development or aesthetics. So they have flunked, the hearing officer has flunked Apple Hill Solar and said you don't comply because of the very specific indications within the Archon district. Can't be on a prominent hillside and three other standards.
Is this information properly for us to consider? Is it in the record here?
Well, what we have argued in the record and in our briefs is that this court needs to do exactly the same thing it did in Apple Hill Solar because the exact same evidence was relied on by the PUC, and that evidence is incompetent, needs to be not either considered or used to make decisions and inferences that are not.
This is the subject of your cross appeal.
So that is the subject of our cross appeal. We want you to do the same thing on Chelsea Solar that you did on Apple Hill Solar, because the exact same evidence was relied on. That evidence needs to be thrown out. The case needs to be remanded for consideration of town plan, instead of saying it doesn't matter because the town signed a settlement agreement. So the reason why I bring this up is because we're asking the court, regardless of their decision on the single plan issue, please to decide on a substantive basis and reverse and remand on the town plan being a clear written community
Well, you
standard.
said regardless of our decision, but if we rule your way, right, if we affirm on it, then it's done, right?
That's true, but here's the problem. Apple Hill Solar is now, apparently, it appears going to be denied the permit. That project disappears, there's no single plant issue anymore, because if half of it goes away, then Chelsea Solar is left as a single plant in and of itself.
You know, we don't know that it's going to be denied. We've certainly seen that the commission takes a close look at these recommendations from the hearing officer and doesn't always come out the same way, right? So we have a hearing officer recommendation and nothing more.
Absolutely, Your Honor, and all we're trying to do, because of the unbelievable amount of litigation that it is. In fact, Mr. Melone, the deposition that he talks about is in a Chittenden Superior civil case where the Malones have sued Libby Harris, the Homeowners Association, and various homeowners, people who aren't even in the development. And that is going on before Judge Tour. I don't know why it's being brought in here. And there are many issues, including Mr. Melone is trying to get Libby Harris's house destructed and removed from her lot because he claims that there was no active 50 amended permit when she constructed her building, even though it was only a subdivision permit for a residential subdivision.
But in follow-up to Justice Robinson's point, we had a hearing officer recommendation in this case, which was not followed by the PUC.
I'm sorry?
Which was not followed by the PUC.
Yes, that's true. That's true. All I'm trying to do is, if there's any opportunity, even though it's not right,
Don't touch.
judicial resources, we would love to reserve to save them.
Can I direct your attention to the intervention issue here? What's the particularized that your clients have?
It is, you didn't get to see the views of how it is impacting on their views. The subdivision, Apple Hill Homeowners Association, is right next door. It abuts the actual project site. Mount Anthony Country Club has views of the site. They have been recognized in the Apple Hill Solar decision, and the Welcome Center can see the site as well. So I'm sorry, I need to reserve time for the
Thank you very much. Thank you.
Thank you very much.
Counsel.
Good morning. Please the court. My name is Sarah Seppes. I'm representing the Vermont Department of Public Service in this case. This has been alluded to in discussions with the appellant, but I would like to highlight one additional question critical to this court's decision, and that is whether the Public Utility Commission's conclusion that the Willow Road and Apple Hill Solar projects comprise a single plant constituted clear error. The answer to that question is yes. The Willow Road and Apple Hill Solar facilities continue to qualify as independent technical facilities under the plain language of Section 8002 of Title 30, as well as the court's 2014 decision.
What's the purpose of the 2 megawatt limit or the 4 megawatt limit on whatever the megawatt limit is on the standard offer program? If it's not, if a developer can simply create 2 adjacent projects and be eligible then for 2 bids rather than 1 project for 1, which would actually be more efficient for the consumer and better for the energy goals, why does that make sense? What's the logic of that?
Well, I think it's more symptomatic of the way the statute has played out, because as you said, it is more efficient at times to have 2 projects in proximity to one another, and so I think more than anything, it's a symptom of how the statute is structured.
And why is it structured that way? Why did the legislature want to limit to these smaller projects? Why was it important to them?
I believe they want to encourage smaller renewable energy projects in the state by smaller developers, and the standard offer program was a way to achieve that.
And why? Why do they care about the size? I'm just trying to get at how does that promote their legislative goals? Or is smaller providers in itself a goal for some sort of?
Well, I think there are numerous goals under Section 801 with regard to renewable energy, one of which is to provide economic benefit to the state and specifically ratepayers. Standard offer and net metering projects try to achieve that.
Well, it's interesting, they've changed the definition of plan, right?
Yes.
I think I understand that both parties agree that it's the definition that applies is the definition that was in the statute before the change occurred. But were we to be considering this under the new provision, under the new language, this would be a far different case from your point of view, wouldn't it?
I'm not sure that's true. The new language, of course, deals with proximity of projects, common ownership, as well as time of construction. However, it's clear that those are to be relevant factors in determining whether facilities are part of the same project and not determinative factors. So while you can find that those three things under the new statute may comprise the same project, they may not share common equipment and infrastructure as part of the second prong of the statute. And it is our position that you need to evaluate both. And I just want to highlight two cases that we referenced in our brief, specifically Southridge Solar Park, where the Commission did not dispute the petitioner's assertion that separate interconnection points on the same interconnection line do not amount to shared infrastructure.
That was a net metering case?
It was.
Is there anything different about the net metering context in terms of the state's policies that might cause a different analysis?
It's under a different statute, but they are very similar statutes. I believe is Section 219 of Title 30 that deals with net metering. It's just a tad different.
They're smaller, right?
Yes, they are smaller. Usually around 500 kilowatts, I believe. However, the Commission has historically interchangeably treated net metering and standard offer projects as the same when it comes to the single plant analysis. And so they treat those interchangeably. I also want to highlight Henry Westman GLC Solar, where the Commission held that sharing a common distribution circuit and sharing a portion of a public road did not amount to shared infrastructure. That is similar in this case as well. And that is all I have, unless you have further questions for me.
Thank you very much. Appellant have time?
Appellant has 2 minutes and 15 seconds remaining.
Your Honor. I just wanted to point out that address footnote 14 of the Allco decision, which addressed the evidence in this case, or in the Allco case, which is very similar to this case, but not identical, is that even if the PUC didn't make all the specific findings that maybe it should have, or implied that it relied too much on the town's non-opposition to the projects, there is still sufficient evidence, more than enough, in the record to show that none of the town plan criteria are a clear community standard. I mean, no one can really say what minimized clearing means. No, and the town already admits that commercial scale solar is permitted in the Archon district. And that was really the main point, is commercial solar permitted in the R5 district.
But I understood the issue to be partly about what the town plan says on its face, and partly about whether the town has in fact enforced the town plan consistent with what it requires on its face, such that it would be given that weight. And so, isn't that an evidentiary question that we would have to allow the PUC to tackle in the first instance?
No, I think as a legal matter, under the court's precedent, none of these criteria are clear community standards. None meets any clear definition of allowing a developer to know what is permitted. And that's the basic criteria. How are you supposed to design a project if you don't know what all these mean? And the town did say that, well, just the fact that they allow them, and their town attorney and the town planner in the 30B6 deposition did say that commercial scale solar is treated like any other use, which means it's permitted.
Is that part of the record?
That part's in the record. Yes, Your Honor.
So how would you write an opinion doing what you want done on that issue that didn't conflict with Apple Hill, with what we said in Apple Hill? What's different on the town plan aesthetics and early development issue here from that last case?
Well, in that case, the court never addressed, one, whether there were clear community standards. We unfortunately didn't use our time in the brief to argue that because we didn't have enough room in the brief. So I think that on the face, well, we argue that now, that these are not clear community standards and that there's really no way any person can say what is permitted, what's not permitted. And so I think it's...
Okay, thank you very much. Thank you very much.
Thank you.
Thank you.
Next, hearing from this court is scheduled for 11 o'clock.
I forgot to. Just gonna stick Pearson on